I'm Drew Stevenson, and this is a video for my Law and Economics seminar about contract law and economics, or the economic analysis of contract law. This video is supposed to be kind of a quick overview or introduction to this field of how we apply law and economics to the field of contracts. And so some of our key terms here are going to be efficiency, exchange or bargaining, and information. So let's proceed. I'm going to draw some insights for this video from Richard Posner's treatise on, or textbook, on economic analysis of law. Richard Posner was a pioneer in this field. He was a Seventh Circuit judge for many years. And in his chapter on contract law, he states that contract law has 5 distinct economic functions, and this is a nice kind of introduction, I think. So first, contract law itself, the fact that we have this body of law and we have courts that enforce these laws, helps prevent opportunism, and that's sort of a fancy word for defrauding people and cheating people. So if you've ever worried when you were engaging in a transaction that the other party was going to take your money and run and you'd never hear from them again, or that you were going to pay someone to do something and they were going to do a terrible job, and so forth. This contract law gives you some recourse, right, especially for valuable contracts. Another economic function of contract law is the judiciary will interpolate efficient terms. So no contract is complete, right? It's basically not humanly possible to have a contract that is so comprehensive it covers every conceivable thing that could go wrong or eventuality that may arise related to these two parties and their transactions or the substance of the transaction. And so all contracts are going to be at least a little bit incomplete or unclear, and judges end up having to fill in the gaps to some extent, or to decipher sometimes confusing or vague terms, or sometimes a contract will contain provisions that are basically contradictory because of sloppy drafting or things like that. And judges can draw insights from economic functions and what would promote welfare and fairness and efficiency and predictability in this area of law when they have to interpret confusing terms, contradictory terms, or fill in the gaps. At the same time, contract law helps create consequences for people who are lazy and sloppy about drafting their contracts and the terms of their agreements. So they don't, they just have an attitude of saying yes and shaking on it and not really spelling out the details, or saying we can address the details later. And well, there's kind of no excuse for not covering at least the basics of what the two parties can expect of each other, because so many disputes arise later on. And so contract law creates consequences, which means it incentivizes people to exercise some caution and care in their agreements, and specifying exactly what they mean and clarifying things in usually a written contract. This is going to be maybe a little less familiar to some students, but contract law helps allocate risk to the superior risk bearer in transactions. This is analogous to our idea of the best cost avoider or least cost avoider in tort law. And the fact is that sometimes when you have two parties in a transaction, like a large corporation and then a individual consumer or customer or contractor, that they're in very different places in terms of coping with or absorbing the loss that could accrue from a circumstance, or let's say tragedy or natural disaster that was unforeseeable to both parties at the outset. And so one thing that courts can do is take into consideration who are the parties we're dealing with and who was in a better position to anticipate this type of risk and either absorb the costs of it or sort of take preemptive action to mitigate the losses for the parties. And then finally, contract law helps reduce the cost of resolving contract disputes. So if we were in a system where there was no, everything was oral contracts and there were no written contracts, then you really, this is very time intensive to sort out later who remembers what was said and exactly what did they mean and what were they thinking, and are we quoting them verbatim, or are they paraphrasing now, and so forth. And so if you have a written contract with clear terms, this really streamlines adjudication or arbitration. It makes it much more likely that the parties can just settle their dispute before trial and so forth. So reducing our agreement to written terms and clarifying some things ends up reducing the costs of resolving contract disputes later. Now, in sort of a big picture sense, when we're talking about national economies and so forth, having a robust system or rule of law system for contract law helps basically develop the economy. It helps foster or encourage investment and economic development because parties are able to reduce risks of uncertain future developments or opportunism. And we'll take a very simple example of the risk of fire, right? And I'm talking about unintentional fire. Fire spreads from a neighbor's property or from a lightning strike or an electrical malfunction or something like that. And so fires can result in catastrophic losses, let's say for business owners, if their whole factory burns down or the warehouse with all their inventory burns down. And if they can make a insurance contract to manage that risk, then they're more likely to kind of proceed with their business, the growth of their business, and engage in commerce. Now, this is not to say that you'll have no transactions in the absence of enforceable contracts, because the fact is people have been making agreements and pacts and treaties and things like that for as long as people have been on the earth, right? People have promised to do things, have engaged in quid pro quo transactions, and traded goods for services and so forth. So some of that will occur. But if the parties have no assurance that the other party will honor the contract and they're going to be left without recourse if the other party defrauds them or cheats them, then they are less likely to engage in transactions at all, and it has a chilling effect on commerce and on the economy. And then you have the extreme hypos, right? A Hobbesian state of nature, like in a failed state. Let's say you have a small country, an undeveloped country, and they've had a coup, and so there's no longer a centralized government or courts. There's some local warlords in certain regions, but in the end, you end up with everybody on their own, having to take care of themselves, and that really discourages commerce and trade and investment, right? Why bother putting up a building if somebody could just come along and take it from you, right? Why bother planting fields if somebody else is going to come and just steal your harvest from you? So what happens in these situations where you have no guarantees and no protection is that everyone kind of devolves into being either a subsistence farmer, so they have a little plot of land where they eke out just enough food to feed their family, or hunters and foragers, right, who are basically just kind of living off the land. And that's a hard life, right? I know there's some people who kind of dream of that because it seems like rugged and cool and rigorous and so forth. But the fact is that it's also poor, right? It's very poor, and you can't have a modern society in that sense. Now, I've talked a lot about opportunism and how a central purpose of contract law is to prevent opportunism. And opportunism is kind of a fancy legal term for cheating or exploiting others. Now, this could be like cheating in the sense of you lied to people and defrauded them, but it could also be sort of seizing an opportunity, right? You realize that the other party is not paying attention or not monitoring to make sure that you've enforced the contract. So let's say a party has paid you, has ordered a lot of goods from your factory, and you realize that they're not really checking the quality of the goods when they arrive. Maybe they open the box and only check the things that are on the top of the container or box when it arrives. So you stick a lot of low quality or damaged items at the bottom, right? So that's kind of dishonest, right? But you didn't, let's say, lie to their face. Or it could be exploiting others, right? That you sort of know that the other person is going to be in a difficult situation. And I'm going to talk about hold-up games in a moment. And so this is a type of opportunism. Opportunism can lead to monopolies, right? So a monopoly is where one party controls the market, and they could hoard the supply, for example, and this could run all the competitors out or somehow seize the supply chains and so forth. And monopolies create a lot of inefficiency and decrease in social welfare because the monopolists can charge as much as they want for whatever type of shoddy or low quality goods and services they want to provide. Opportunism leads to unfairness, and it leads to the risk of extra legal revenge activity, right? So I want you to imagine a society where we don't really have functioning courts for contracts, and you're going to be left without recourse. A lot more people are going to take the law into their own hands, so to speak, and that's very dangerous and costly, right? If you have to imagine a world where you have to have a shootout to resolve every dispute, you go to a restaurant and order something and you don't like what they think, they bring you your food and it's cold and you send it back, and now you have to have a duel over your lunch, right? So a lot of people would just start avoiding interacting with other people if they knew that every engagement, if any, there's any disagreement at all, it will have to be resolved with violence, because violence is risky and very costly, and there's a lot of spillover effects and so forth. Another type of opportunism that you probably encountered in your first year contracts course are hold-up games. So the classic example is a plumber or a mechanic. So let's say you have a leaky pipe or a leaky faucet, and you hire a plumber and offer to pay that plumber $100 to come over to your house and fix your leaking faucet or your clogged drain. So the plumber comes and they take your sink all apart and take all the plumbing in your house apart. And they've shut off the water. None of your toilets work. You can't take a shower. They've had it off for a couple of days. And then they basically jack up the price and tell you it's going to be $2,000 instead of $100 to fix your plumbing, because the problems are just so much more extensive than they anticipated. And so this is kind of a bait and switch, right? Or a holdup game where they lowballed you to get you to agree. And then once the contract is partly underway, they know that you're going to be in a bind. So builders sometimes do this, right? So you'll have a builder, and when who agrees to do a building for a certain amount, and then or a construction project, and then when it's about halfway done, and you really don't want to have to hire a different contractor, right, to finish a job, they basically say, look, we're having cost overruns, and it's going to be a lot more expensive. Some of you have had the misfortune of taking your car to a mechanic for something simple like an oil change or a brake job, and after they have your car up on a lift and partly disassembled, the mechanic tells you that it's going to be 5 times as much as you thought, because they have to replace the entire exhaust system, or you need a new transmission or something like that. And they kind of have you in a bind, because you can't just say, no, thanks, I'll go get a second opinion, if they already have your car up on the lift and have already done some work on the car. So contracts, now, obviously, I can still give examples because contracts don't completely prevent this, but it does minimize the amount of opportunism. And when there's less risk of opportunism, people will just kind of go about their day and engage in business and commerce, and you can have a sort of a thriving society with a lot of economic activity. Contracts also help with the human inability to foresee the future. Now, no matter how good you are at making predictions, there are some things that happen in each of our lives and in the world around us that we really couldn't see coming, or that catch everyone off guard, right? So if everyone knew that the stock market was going to crash, it wouldn't crash, right? Because everybody would have managed their investments accordingly. So wars, another pandemic, right, that disrupts supply chains or shuts down a lot of businesses and activities, or eliminates a huge percentage of the workforce. That's happened in our history at times. Natural disasters like hurricanes and major floods or tornadoes, wildfires, all of these things that are hard to predict, that are basically, we know that they're out there, but they're uncertain. That's another reason for contracts. And to make the very simple example, unpredictable changes in prices, right? For either, if you're a manufacturer, the supplies that you need, or the transportation to get your goods to market. And so if you know that there could be huge price changes in the cost of fuel or the cost of supplies, you might want to make a contract so you can lock in what you think is a good or fair price, right? And either a price to buy stuff or a price to sell your stuff. And the other party might also value locking in the price because they are also unsure about what's going to happen in the marketplace that relates to that particular transaction. An example that's very familiar about basically trying to reduce risk is paying seat deposits for law school or college, right? So after you have been accepted into it, you've gotten your acceptance letter into a school, and maybe you've notified them that you plan to attend. The fact is the school knows that a certain number of students are just not going to show up. They got off the wait list into a higher ranked school, or decided not to go to school right then, or to go to the school, college, or law school in another state, or so forth. So schools will ask for seat deposits to partly to get you to make a commitment, and partly to try to reduce their uncertainty about the number of people that they're students that they're going to have in their incoming class. And it makes it easier to plan, like how many professors do we need to cover courses and so forth. Now, we talked about the efficiency of judicial gap filling for vague or incomplete contracts. And I want to talk about why that's a good thing, right? As I mentioned before, it's not humanly possible to have a contract that contemplates every conceivable eventuality, right? Anything that like the 1 in a million chance occurrence that of something that could go wrong. And so if you know that you can rely on the courts to do the right thing and to follow predictable rules and how they're going to fill in the gaps, it reduces the need for kind of endlessly protracted and costly negotiations for every single contract, right? I mean, nobody needs a 300-page contract for a residential apartment lease, or to get your hair cut, or to make a reservation at a restaurant or something like that, right? So all of these are pretty simple, straightforward contracts that we have streamlined, and you know that if somehow something goes wrong, that that there's going to be recourse, and that there's predictable rules that will be followed. And that allows you to draft a contract that is somewhat intentionally incomplete and gives the parties a little bit more flexibility, and certainly saves everybody's valuable time. And so now you do have to have the basics, right? You want to have something in place, the essentials of the contract. And if judges can figure out some of the details and the judges are going to be predictably fair, then the parties can skip some of the details in their contract and let the courts decide. And that concludes my quick introduction to the law and economics of contract law.